So this change relates specifically to employers with 15 or more employees. So if you have less than 15 employees, then you just need to be ready to assess requests from your casuals. So this change passed by Parliament in March 2021 relates to a new entitlement being added to the National Employment Standards, the NES, and it gives casual employees a pathway to become a permanent employee. So this is known as casual conversion. So the NES now have 11 standards, not just the 10. So if you do have 15 or more employees, you're not deemed under the Fair Work Act to be a small business, and therefore you're now required to do two things before September 27th, 2021. First of all, you need to proactively provide a written offer to convert to full-time or part-time permanent employment to all those casual employees who have been employed by you for a period of 12 months, beginning the day their employment started. And during that 12 months, at least the last 6 months of that period, they've been working a regular pattern of hours on an ongoing basis and could continue working those hours as a permanent employee without significant changes, and hold the position that's not due to cease to exist in the next 12 months, where the transfer to permanent would not result in the hours of work they're required to perform being significantly reduced, or a significant change in the days on which the employee's hours of work are required to be performed, or a significant change in the times at which the employee's hours of work are required to be performed, which can't be accommodated within the days and times the employee is actually available to work. And the final one is non-compliance with the recruitment or selection process required by or under Commonwealth, state or territory law. So that last one really just relates to government employees. And the second action you need to take is respond to the employee in writing, notifying the casual employee of the decision. So that's a requirement now as well. So what has changed? Well, prior to this, the only pathway for a casual to convert to permanent was for them to submit a request to convert. However, now employers with 15 or more employees must proactively offer it. So if you have less than 15 employees, nothing has changed. You just continue with the casual conversion process stipulated in your award, whereby your casuals are able to request to convert to permanent if they believe they're eligible. So now we'll get on to what you need to do. What to do prior to September 2021 depends on whether you have 15 or more employees or less than 15 employees. So if you have 15 or more employees, you need to take the following 5 steps before September 27th, 2021. The first one is you need to ensure you've given out all casuals the CEIS, which is the Casual Employment Information Statement. Secondly, you need to check that you have an onboarding procedure set in place. I really recommend you getting your procedures set up now. Check you have the onboarding procedure set in place, whereby all your new casuals from now on are provided the CEIS, and you have evidence that it's being given. And also, I recommend a reminder alert is added to your onboarding procedure there as well. Just so that that alert is placed in your calendar for the 11th month, for example, 11th month anniversary of any new casuals. So you'll be reminded to assess their eligibility to convert at that time. So the third thing you need to do now is go and pick a date. Look at the calendar, work out what date you're going to conduct your casual conversion audit of all your casuals. So this could be, for example, September 1st. And the fourth step you need to take is conduct the actual casual conversion audit of your existing casuals. So this is about assessing their eligibility against the criteria I just took you through. And if you're unsure how to go about this audit, you can use our casual conversion audit checklist, which we've developed, and we put that on our Fair Work Compliance resources page of our website. So if you go to our website, www.hrtactics.com.au, and across the top look for resources, and the drop down menu will include their Fair Work Compliance resources page. So I'll give you an overview of the steps in that checklist shortly in this video there. And the final fifth and final step that you'd need to take is to be ready. Be ready. Make sure that you're on the front foot and ready. You know what procedures you need to follow when you receive a request to convert from your casuals. So on receiving a request, you will need to work through a series of 4 steps. I'll take you through these in a moment in more detail, but they do cover, firstly, assessing their eligibility, consultation with the casual, responding to their request, and conversion if they're eligible. So we've put these specific steps into a casual conversion request checklist, which again we've placed onto our website on the Fair Work Compliance resources page. But I'll talk you through in an overview of these steps in the video as well in a moment. So, but firstly, I'll just go back to the casual conversion audit checklist. I'll give you a bit of an overview here of the casual conversion audit you need to do to all of your existing casuals before September 27, 2021. So step 1 is to look at the start dates of all your casuals and ascertain who meet all of the following eligibility criteria. So you're looking for those who have been employed for a period of 12 months, beginning the day their employment started, and during at least the last 6 months of that period have worked a regular pattern of hours on an ongoing basis, and could continue working those hours as a permanent employee without significant changes, and are in a position that is not due to cease to exist in the next 12 months, and transferring them to permanent wouldn't result in hours of work they're required to perform being significantly reduced, a significant change in the days on which the employee's hours of work are required to be performed, a significant change in the times at which the employee hours are required to be performed, which can't be accommodated by the employee. They're not available at those times and days, and non-compliance with a recruitment or selection process required by or under a Commonwealth, state or territory law, which before, as I said, relates to government employees. So then for those eligible casuals, you need to provide them with a written offer to convert to full-time or part-time employment, and you need to do this within 21 days. So that's why I'm recommending it's an action you need to take now to prepare so you have these processes in place. So the details you need to put into this written offer letter are listed for you in our casual conversion audit checklist on the Fair Work Compliance resources page. So you've assessed the eligibility of all your casuals and you've sent off the written offer to those who are eligible. What do you do next? Well, that's going to depend on whether they accept or decline the offer that you've given them. So when you receive an acceptance in writing, you must within 21 days do a few things. Discuss the permanent arrangements with the employee, the hours of work, for example, etc., etc. Convert them to permanent in your payroll system to commence within the next full pay period, or it can be on another date, but that needs to be agreed between you and the employee. And the third thing you need to do if they accept the offer is provide them with a permanent part-time or full-time employment contract, or for those of you with an enterprise agreement, it possibly is a letter of appointment. If you receive a declined offer in writing, you must, within 21 days, confirm in writing to them that you've received the decision to not convert. So that needs to be in writing, so that closes off that process, and obviously put all this onto the employee file. If by chance you don't receive anything, you don't hear anything back from the employee, you must within 21 days confirm to them in writing that you have not received their response and therefore have assumed that they've declined the offer. So that one won't go any further. So let me now jump over to talk you through an overview of the process to follow when you receive a request to convert. So this will be an ongoing process, ongoing through time. The first process was an audit of all your existing casuals that needed to be done before the 27th of September 2021. Now I'll talk you through very briefly the process when you casual requests to convert. So remember, if you're unsure how to manage the requests for casual conversion, you can download our step-by-step casual conversion request checklist on our Fair Work Compliance Resources page. So firstly, you obviously need to assess their eligibility as per the criteria that I went through. You then need to consult with the employee as to your view of their eligibility and then respond to their request, and that needs to be in writing within 21 days, advising whether you do deem them to be eligible, and if not, you need to explain why not. So which of those eligibility criteria are not being met, and then obviously convert them to permanent, part-time or full-time if they are eligible. So what to do pre-September 2021 if you have less than 15 employees? Well, because small business employers are exempt from having to proactively offer the option to convert to their eligible casual employees, you're only required to advise your eligible casuals that they have the right to request to convert if they are eligible casuals. And you do this by providing them with the CEIS, the Casual Employment Information Statement. So if you have less than 15 employees, there are 3 things I recommend you do as soon as possible after March 27th, 2021, which is obviously gone now. Number 1, ensure you've given all your casuals the CEIS, along with the Fair Work Information Statement, obviously, but make sure you've given all your existing casuals the CEIS. So to make sure you're going to give all your future casuals the CEIS, go ahead now and check that you have an onboarding procedure set in place whereby all your new casuals are going to be provided with the CEIS along with the Fair Work Information Statement, and you have evidence that it's being given to them. So the third recommendation here for action is to get prepared and be ready to receive requests to convert from your casuals, because on receiving a request you will need to work through a series of steps within 21 days, and those steps are involving assessing their eligibility, consulting with the staff member, responding in writing to the request, and then converting them if they are eligible. Again, if you're unsure how to manage the requests for casual conversion, you can download our step-by-step casual conversion request checklist on our Fair Work Compliance Resources page of our HR Tactics website. So I'm going to finish up here with some questions that we've already been having come through from clients and through our HR Q&A section on the front page of our website. One is, when is an employee ineligible to make a request? So an employee isn't eligible to make a request if in the last 6 months they've either refused an offer from you to convert to permanent employee, or they've been told by you in writing that you won't be making an offer of casual conversion because there was a reasonable grounds not to make that offer. You have refused another request for casual conversion because there was a reasonable ground to refuse that request. Another question that's come through a lot is how often can an employee make a request for casual conversion? So casual employees who believe they're eligible to become a permanent employee can make a request for conversion every 6 months. Sometimes employees can still make a request even if their employer has told them in the last 6 months that they won't be making an offer of casual conversion. So employees can only do this if they didn't get an offer because they hadn't worked a regular pattern of work in the 6 months before their earlier request, but they now have worked that regular pattern of work in the 6 months. And a final point here, I really want to impress this upon everybody here. It's about protections at work. So it's really critical that you remember here that an employer, that you guys can't reduce or change your employees' hours of work or go ahead and terminate their employment to avoid having to offer or accept a request for casual conversion. So why is that? Well, because casual employees are also protected as permanent employees are, they're also protected against adverse action by an employer because they have a workplace right to convert to permanent employment. Casual employees may also be protected against unfair dismissal by an employer if they're regular and systematic casual employees. So what does this mean? It means that if you go ahead and deliberately change an employee's roster so they don't meet eligibility criteria, the casual employee may have grounds to lodge an adverse action claim or an unfair dismissal claim against you. So, a lot of information to take in this fourth video. If you have any queries about the information we've gone through, maybe have a read through, listen to it again, or have a read through the transcript which we've provided. And don't forget to reach out to us, ask us questions. We've got our contact details on our website or the Contact Us page, or there's the HR Q&A section on the front page of our website. I'm Jackie Strawn, CEO of HR Tactics, really hoping this has brought some clarity to you, and reach out if it hasn't.